But there are two other key, I think, purposes of discovery. The first is a more intangible one, which is that as a representative of a plaintiff, you know very little about what actually happens in the workplace. The only window that you have into the workplace is through your client's description of their experience there. It's important if you go to trial and if you are to really understand the case to get a much broader and deeper sense of what it was like to actually have the experience that your client had at that workplace. So you need to get a lot of information about how the workplace actually operated, the policies, the procedures, whether those policies and procedures were followed or not, the organizational structure of the organization, and all the other details and data that you need in order to get a picture in your own mind and create a picture in the jury's mind as to what it was like to actually experience life as a worker in this workplace, so that you can then tell your story about how this life in the workplace caused your client harm and pain. You want the employer to commit itself to a position. If you have decided that you're not going to go through the position statement, rebuttal, memo of facts and law, probable cause sequence at the MCAD, this is the interrogatories that you serve, or the discovery request you serve after your complaint is the first time that you're going to have a chance to get the employer to commit to a position. You want to do that early because as they have time and as more evidence surfaces, their responses generally become more nuanced, more complex, more substantive. The earlier you can get them down on paper under oath to say, this is why we fired your guy, for example, makes it that much harder to say later, oh, well, we didn't fire him because he was late. We fired him because he was embezzling for 3 years, or whatever the shifting explanation for what you did is. Of course, we like it when they try to do that because we see that as excellent evidence of pretext. But in order to establish the shifting reasons, you got to get the first reason down first. And so you serve the discovery early. It also maximizes the sort of emotional impact of having a complaint land on your desk. It's going to be one of the first opportunities you're going to have to tell the judge your story about your case. So you want to, and it's also one of the first opportunities you have to really assemble all the facts and put them together in a compelling story. So you should look at that as an opportunity, given that you're almost inevitably going to have to do it, you look at it as an opportunity to put your story together and to tell it to the judge. The only other the other thing I would say about it is that you have to make sure that there were a couple of cases in recent years where people were a little less than clear as to what the disputes of fact were and what weren't in their response to the summary judgment motion. You have to be clear about that. You can do that and tell your story at the same time, but make sure that you do it both on a meta level, so you can say the clear disputes of fact here are whether our client was discriminated against, and also on a micro level. So when they come and say, their client admitted that there was no discrimination, that they took $10 out of the till, you can say, you specifically dispute that fact. You assert the evidence and attach the evidence that effectively disputes it, so that the court can't then later come back and say, we had to spend too much time trying to figure out what the disputes were here. In general, every case, there's going to be many disputes of fact, and your job is to make that clear to the judge.